is letting you know that I don't hate you.
I miss him so much, and it's your fault.
A man in St. Johns County learns his fate today, 2 years after a DUI incident.
To serve 41.0125 years on each count to run concurrent to each other. On the misdemeanor charge, I adjudicate you.
A St. Johns County judge sentenced Michael Ryan to 41 years in prison. He pleaded no contest to a DUI crash that killed a man, injured his sister. The incident occurred the day after Christmas in 2020. Ryan was drunk that night, driving the wrong way on County Road 207 and hit the victim's car head-on. During the sentencing hearing, Raquel Haralambo finally confronted the man who admitted to causing the drunk driving crash that killed her younger brother and her twin daughters. It was a powerful moment, filled with overwhelming grief, anger, and a sense of absolution.
Something I have to get off my heart is letting you know that I don't hate you. I want to, but I can't.
Haralambo, who lost the ability to have more children due to her injuries from the 2020 crash, was visibly emotional as she spoke to the man responsible. Now 33, Ryan pleaded no contest to 3 counts of vehicular manslaughter and other charges, admitting he drove the wrong way on State Route 207 with twice the legal limit of alcohol in his system. His truck slammed head-on into the car, carrying Haralambo, her daughter, and her younger brother. In the courtroom, Ryan appeared broken, shedding tears for most of the sentencing hearing and offering a statement of remorse.
Every day, why was I not taken instead of the ones that were? Your Honor, I hate myself every day for the void that has been left.
Facing decades in prison, Ryan committed to spreading awareness about the dangers of drunk driving with any free years he has left. In closing arguments, Ryan's attorney highlighted his remorse and pleaded for leniency. However, prosecutors emphasized Ryan's choice to drink and drive that night, pointing to the lives lost and those forever changed, including Haralambo's.
I ask you to take into account that the years Michael serves in prison will be shorter than any of their lives.
When it came time to impose the sentence, Judge R. Lee Smith described it as perhaps the most emotional and heart-wrenching hearing he had ever witnessed.
No matter what sentence I impose, no matter how long I put you in prison, you are never going to escape the haunting memories of this incident and the haunting and impactful words.
Ryan was sentenced to 41 years for the 9 charges, including deadly DUI, vehicular homicide, and reckless driving. Before handing down the sentence, the judge pointed out a particularly painful aspect of the case. It was all avoidable. He emphasized that this should serve as a dark reminder of the dangers and detrimental effects of drunk driving. Ryan now has 30 days to appeal. On Friday, October 19th, 22-year-old Matthew Jordan Carrier was in court for sentencing on 19 counts stemming from a May 2017 incident. Carrier, who was drinking with friends, drove while intoxicated, causing a crash in Osceola Township that killed 5 and injured 2. Carrier, who has a lengthy record and was driving on a suspended license, listened to hours of impact statements from the families of the deceased before his sentencing.
There's not a day that goes by that I don't think of you. Everyone said they hate you in an unimaginable way. I could say I hate you, but that wouldn't change anything. 5 good people got killed, and I say I hate you, but I can't. My heart just won't let me. You, Matthew, one of the big things keeping me happy. I woke up every day waiting to get home and hug him so tight. I miss him so much, and it's your fault he's gone.
Justin was a wonderful son, brother. He loved his brother Andrew and his sister Elizabeth.
Nothing is the same anymore without him. Holidays, birthdays, our annual Thanksgiving football game, and our Christmas, after the Christmas dinner board games. Preston is truly missed. There's a hole and emptiness in our lives. We have learned to live our lives in a new normal,
Regarding the son loss of our father, Jerome Joseph Tormasi, last May 9th, 2017. On May 9th, we not only lost our father, but our world lost so much more. He was not only a wonderful, loving, and caring father, but he was a wonderful grandfather to my sisters, to my sons, and an amazing, caring brother.
This girl, you took out the one person that if you had not done what you did and fatally did what you did, she would try to find the best in you and try to bring out the best in you and make sure that this never happens again. She would get to the root of your problem. She would figure out what's on your head that's wrong because something's broken in there. Whether they broke you or somebody broke you, you're broken. Your only job from this point on is to that broken person and create someone new. That is your only job. And however long it takes, or however long he said you're going to contemplate and do it, you're going to do it because the universe told you to do it. And if you try again to get out of it, whether it be new counsel or whether it be anything, oh, karma's coming for you one more time.
We've heard about how you've had a rough life, that your father wasn't around to help raise you, how you got into drugs and alcohol at a young age, you were homeless, mental illness, etc. I don't know if I'm supposed to feel sorry for you. I don't know what to feel. Trouble. You chose to drive drunk when you were arrested for your first DUI. You chose to drive drunk on May 9th. We live in a world of Lyft and Uber, one touch away from a safe drive home. If you drive drunk, you have the intent on innocent people. For you, Matthew, ignorance is no excuse. My mom was healthy and had many years of life ahead of her. My mom was...
His attorney read a statement from Kyle Lexi's mother asking the court for mercy, and Carrier also read his own statement.
I should have slowed down, opened my eyes, saw the situation for what it was, and really thought through what I was doing. I realize now that this moment is all there is. I see how important it is to use it wisely and to be mindful of the consequences. I've known that alcohol was a problem for me, and I still chose to drink.
Livingston County Circuit Court Judge Michael Hattie sentenced Carrier to 32.5 to 60 years in prison. This is Morgan Geyser from Waukesha, Wisconsin, facing charges for the attempted murder of her then best friend, Peyton Leutner. On May 31st, 2014, in Waukesha, Wisconsin, Morgan Geyser and Anissa Wire committed an unspeakable act that will forever change their lives. They lured their friend, Peyton Leutner, into a forest and stabbed her 19 times in an attempt to appease the fictional character Slender Man.
First.
I think Anissa her first, and then I continued, and like she was like, Morgan, make sure she doesn't miss this game.
She told me that she got her in the lung right here 6 times, and then like in the leg a few times. So we told her we were gonna get help, but we really weren't. We were gonna run and let her pass away. So we ran.
Remarkably, Leutner survived and was found on a road where she was rescued.
Upon a 2-year-old female, she appears to be...
She appears to be what?
Correct.
Are you with her right now?
Yes.
Is she awake?
She's awake.
Is there any going on?
Her clothing has got on it.
Okay, and you found her and she was just laying there?
Yeah.
Despite being arrested, Morgan Geyser appeared unaffected by what had just happened. Interrogation footage showed her singing and dancing shortly after being apprehended.
Are you going to put me in prison and I'm gonna rot and die? Please don't f my head. I'm just waiting. And I'll be preparing and hold on the outside. Sometimes I'm looking in.
Geyser was later charged with attempted first-degree homicide, and both she and Wire were tried as adults. With overwhelming evidence and the horrific aftermath, Morgan Geyser's fate was almost certain. She received a severe sentence of 40 years to life, with a requirement for psychiatric treatment. Dane County Circuit Court Judge Stephen Elka became emotional while reading an impact statement from one of Alec Cook's victims.
Letter from victim number 7. She says, in part, quote, "Feelings of shame and worthlessness consume me as I had to admit to myself that Alec Cook had preyed upon my kindness, which I then began to see as a weakness," end quote. I want her to know that I also have read her statement, and she has nothing to feel shame about. She did nothing wrong. Please continue to be kind.
This is Quincy Tuttle, who planned to settle a school dispute with a violent attack on his classmates. His alarming arsenal was discovered after his mother reported missing kitchen knives, leading to his arrest and a 2-hour lockdown at the school.
Prosecutors say a 20-bore semi-automatic gun was found and 2 loaded.
Tuttle faced serious charges, including attempted assault, unlawful possession of a firearm, and possession of a weapon at school. As the trial proceeded, a dark side of this boy emerged. Quincy Tuttle was sentenced to 2 years in a juvenile detention facility for his actions. He pleaded guilty to 2 counts of first-degree attempted assault, theft of a firearm, second-degree unlawful possession of a firearm, and possession of a dangerous weapon on school property. This is Gregory Ramos, a teen who killed his own mother in cold blood in DeBary, Florida. A chilling event unfolded on November 2nd, 2018. Gregory Logan Ramos strangled his mother, Gail Elaine Clevenger, after an argument over a bad grade. The nation was horrified as details emerged about the case. Ramos buried his mother beneath a church fire pit and methodically cleaned the scene. The calculated nature of his actions was especially shocking, given his age.
I mean, across the face, she began to hit me. She started me. I didn't like it, so I strangled her. I put her in a wheelbarrow. I put her in my car. I took the car. I had a mental breakdown where I almost committed suicide 3 times. I drove back to the church. I began to dig a hole. I dig a hole right under the fire pit. I dug a pretty deep hole, pretty deep, deep enough to put a body in, all right?
All the stones were arranged. It was a fire pit, and this is where him and his friends would always come. We did a cursory search. Unfortunately, her foot was protruding after digging down maybe 8 or 10 inches. That's not really a big place to where he put his mom.
The charges were severe: first-degree murder, abuse of a corpse, and tampering with evidence. Ramos pleaded guilty. His friends, Dylan Seglarek and Brian Porras, were also charged as accessories for helping to cover up the crime.
I checked the entire house because I was looking for her, but she's not here. I just got home, and my house is completely trashed. It looks like someone broke in the side door.
With compelling victim statements, overwhelming evidence, and cold calculations in executing the crime, the verdict was never in doubt. Gregory Ramos was sentenced to 45 years in prison.
Sentence for count 1 is 45 years in the custody of the Florida Department of Corrections, followed by lifetime probation. Probation will have the standard conditions with the special condition of a mental health evaluation.
Meet Willard Miller, a high school student who killed his teacher over bad grades.
Unspeakable. That's the word one school official is using to describe the murder of a beloved high school teacher. Her body, with severe trauma to the head, was found hidden in a local park. And now 2 17-year-old students have been charged as adults in her.
A high school student, Willard Miller, stands accused of brutally killing his teacher over bad grades. In an act that stunned the community, Miller beat his beloved Spanish teacher with a bat until she stopped moving.
¿Qué tal? Buenas noches.
66-year-old Noema Graber was found beaten in a park where she regularly went for walks after school.
Miller and his accomplice, Jeremy Goodale, were tried as adults and faced first-degree murder charges. Goodale soon cooperated with prosecutors to get a lighter sentence.
I offer my sincerest apologies to the Graber family, but I know my words will never be enough. I've had time to think on what to say, and I'm sorry. Truly sorry. I'm so sorry. To Mrs. Graber's friends and the members of her church, I'm truly sorry for what I've taken from you.
Goodale provided gruesome details of how the murder took place.
On November 2nd of 2021,
I met Willard Miller at Chautauqua Park. I understood that he had the intent to Mrs. Graber. Shaden had brought a bat, among other supplies, to go through with. And after he had struck Nohema Graber, we then moved her off of the trail, where I then struck her, and she did the result. Afterwards, we removed any evidence that we could, and that was my recollection of the events on November.
During Miller's trial, the victim's son emotionally testified, honoring his mother's legacy.
I forgive them and feel sorry that they had that anger in their hearts. There's no point in being angry at them. My mother was an angel of a woman and was one of the kindest souls.
Faced with compelling evidence and heartbreaking testimonies from the victim's family and school community members, the verdict was never in doubt.
The court finds, based on the nature and circumstances of this offense, along with the required 25 factors that I am to consider in sentencing a juvenile in the state of Iowa in the first degree, that the defendant, Willard Noble Chaden Miller, should be sentenced to life with the possibility of parole after 35 years. This sentence is permissible under the Iowa law. A 35-year mandatory minimum is not cruel and unusual punishment for the defendant, as it represents the appropriate time of incarceration for the defendant and Mr. Goodell's premeditated.
Social media star Nikita Dragun appeared in Miami-Dade bond court after being arrested for battery of an officer during an incident at a Miami Beach hotel. During the hearing, Dragun asked the judge if she had to stay in the men's unit.
Can we just confirm how
Page
the
6.
like to be addressed?
Page 4.
It's a little confusing.
What is it? What'd you say?
Sorry, the volume was down.
Hello. Ma'am, you were arrested for battery on a corrections officer, disorderly conduct, or no, battery on a law enforcement officer, disorderly conduct, and then a battery in violation of a county city ordinance. I will appoint the public defender's office for you.
It looks like the defendant.
Nikita, please do not make any statements or comments while we're here in court.
You want me to
about
call
what
you
happened
miss?
In your case, okay?
Or what would you prefer me to address you as? Your title?
She.
Can't hear, I'm
So
sorry.
it looks like she's here on.
She and her.
Oh, okay, that's fine, thank you.
It looks like she's here on vacation.
Oh, from New York.
Right, and there was an incident at the hotel.
So let me read what happened. The Good Times Hotel. Okay. The battery is throwing water or spilling water at the officer and the security guard.
So no objection to reducing the bond.
You're going to order that you stay away from the Good Times Hotel. Do you have to go there to get your personal belongings?
I do.
All right. So you're not allowed to go back there, but you can return there to get your personal belongings. Otherwise, you got to stay away from there. And if you go there to get your personal belongings, I don't know, you want to stay away with her? She doesn't live here.
I mean, I think that she caused trouble at the hotel. I don't think they want her back there. And I don't think it's too restrictive.
All right, so just go there to get your personal belongings. You should go with a police officer, okay?
Thank you so much. I would like to thank the staff. They've been very lovely.
All right, let me just write this out. I don't know, what do you want me to do?
You just reduce the bond.
Do you have money to post the bond?
How much is it?
I don't know.
I was thinking 1,000 count 1, and then 500 2 and 3.
That's fine.
I might have to check.
$1,000 count 1, 500 count 2, 500 count 3.
Judge, would you consider an ROR?
I can't do that for this charge. I'm sorry.
And the defendant's not from here,
I
so.
can't, I gotta set a bond. It's a $2,000 bond. If there's any reason you can't afford to pay a bond, use the free phone at the jail to call the public defender's office, and they can readdress this with your division judge. All right?
And Your Honor, may I ask one question?
Sure.
Do I have to stay here in the men's unit still?
Yeah, I don't make the rules up there, but they should make a proper accommodation for you. You should be in a separate area. You can contact the bondsman to try and get you out. Miss Corey, do you want to note your file that makes to follow up to make sure she's able to get hold of a bondsman to bond out?
Yes, Judge. Miss Dragun, can I please have your phone number or contact number that once you're out we can get in touch with you?
Yes, ma'am. It's the same one I've had my entire life.
So when you get out, please keep in touch with the public defender's office, and I'll make a note for the attorney to reach out to you soon and see if we can get in touch with the bondsman, okay?
Fiona, can you repeat the bond?
Sure. It's $1,000 count one for the battery on the law enforcement officer.
Meet Jeremy Schuh, a 39-year-old facing serious charges, including first-degree home invasion, car theft, identity theft, and possession of a controlled substance. Schuh arrives in a wheelchair, having suffered multiple strokes. Throughout the legal proceedings, Walter White's attorney is always by his side.
Matters. I would just restate my previous request.
Schuh's lawyer has just asked to step down from representing him. Even though Schuh is wheelchair-bound, his attorney is uncertain about the seriousness of his condition.
What his physical health is, but I know that he's maybe not as strong as he used to be. And so I would just ask Your Honor to consider allowing me to withdraw so that he can get an attorney that he can work with.
Unexpectedly, Schuh chooses to represent himself when things don't go his way. Tensions escalate, and two court officers stand behind Schuh, ready in case things get physical. They forcefully make him sit back in the chair, but Schuh doesn't comply quietly. Ultimately, Schuh sticks with White as his attorney, proving to be a smart move. White negotiates a deal where Schuh pleads no contest to most of the charges, resulting in a reduced sentence of 2.5 years in a county jail. Julio Caesar was escorted out of district court, facing a lengthy prison sentence. The woman he shot during a carjacking attempt in November 2021 expressed her satisfaction with the outcome.
It was 45 years. I just started crying because it's not just for me, it's for the other victims as well.
Rivera was accused of a series of armed carjackings totaling 5. He pleaded guilty to 3 cases, including the attempted robbery of Alana Castaneda, which resulted in a reduced prison sentence.
It's not justifying what I did. Nothing's going to make it sound okay, because it's not.
Separate federal court records reveal that Rivera told the police a friend had asked him to steal a car for human smuggling. His family requested leniency, explaining that Rivera grew up without his biological mother and got involved with the wrong crowd.
I appreciate that his parents might think he was put up to it, but these were his choices, these were his decisions. This was his gun.
Before his sentencing, Rivera apologized directly to Castaneda.
I got a lot of time to sit here and think about what I've done. I'm not the same person I was 2 years ago. And I pray every day for forgiveness and just for being good health.
Seeing Rivera again was difficult for Castaneda. She has already undergone 3 surgeries, with a 4th on the way, and bears permanent scars from the violent encounter.
Yes, I was listening to him, but at the same time, it's you did what you did.
An Iowa mother, Michelle Kehue, 36, was sentenced to life without parole for assaulting her son and leaving him to die near a remote pond in October 2008. She also received a 25-year sentence for attempting to kill her other son. Kehue left both children outside the family van before attempting to take her own life. The 7-year-old survived and provided crucial testimony against his mother. Her attorneys argued that she believed she was saving her sons from a life of suffering. However, the jury rejected her insanity defense and convicted her of first-degree murder, attempted murder, and child endangerment.
Now, after you took these photographs, did you continue on? Permission to play that second part of the video. Yes, you may.
Just gonna go underneath here. Here we are, honey.
morning when you got injured? Okay. Did Mom do anything else? How'd she do that?
Put duct tape over my eyes and my nose and pieces.
Several pieces. Did you have to pull those off, or did somebody else?
I pulled them off. My baby brother.
She was her baby brother at that time? Okay.
Kehue also received a 10-year sentence for child endangerment for injuring her older son. Despite her husband's objections, Judge Bruce Zager extended the prosecution's request for a no-contact order, preventing Kehue from contacting her surviving son or anyone he lives with. The case revolved around a man named Adam Matos. In August 2014, Matos' ex-partner Megan Brown made several 911 calls complaining about him. Later, the bodies of Megan, her parents Margaret and Greg Brown, and her new boyfriend Nicholas Leonard were found on a hill in Pasco County. With Matos confirmed as the suspect, the police decided to arrest him. While every relationship has issues, some can turn violent, as seen in Matos' case. The jury had to consider all the facts before delivering a just verdict.
In the Circuit Court of the 6th Judicial Circuit of the State of Florida in and for Pasco County, case number 2014 CF 005586 AXWS, State of Florida versus Adam Matos. Indictment for count 1 in the first degree. Verdict. We, the jury, finds as follows. The defendant is guilty of in the first degree as to Nicholas Leonard as charged in the indictment. So say we all, this 16th day of November 2017, signed the foreperson, juror number 10. Indictment for count 2 in the first degree. We, the jury, finds as follows. The defendant is guilty of in the first degree as to Megan Brown as charged in the indictment. We further find the defendant did possess, display, use, threaten to use, or attempt to use. We further find the defendant did actually possess. The defendant did discharge a. The defendant did discharge a causing or great bodily injury of Megan Brown. So say we all, the 16th day of November 2017, sign the foreperson, juror number 10. Indictment for count 3 in the first degree. We, the jury, finds as follows. The defendant is guilty of in the first degree as to Gregory Brown as charged in the indictment. We further find the defendant did possess, display, use, threaten to use, or attempt to use a. We further find the defendant did actually possess a. The defendant did discharge a. The defendant did discharge a causing or great bodily injury of Gregory Brown. So say we all, this 16th day of November 2017, sign the foreperson, juror number 10. Indictment for count 4 in the first degree. We, the jury, finds as follows. The defendant is guilty of in the first degree as to Margaret Brown as charged in the indictment. So say we all, this 16th day of November 2017, sign the foreperson, juror number 10.
All right. So the defense wish to have the jury polled?
Please, Judge.
All right. Ladies and gentlemen, we're going to poll the jury. The clerk will call your seat number, and it's a yes or no answer. She's going to ask if the verdicts that she has read are in fact your verdicts. If they are, please say yes. If they are, say no, and she'll do it by seat number. Madam Clerk?
Would you like me to go each count one after the other?
No, we'll just do it as a whole. That's fine.
Okay. Juror number 1, is the verdict rendered your verdict?
Yes.
Juror number 2, is the verdict rendered your verdict?
Yes.
Juror number 3, is the verdict rendered your verdict?
Yes.
Juror number 4, is the verdict rendered your verdict?
Yes.
Juror number 5, is the verdict rendered your verdict?
Yes.
Juror number 6, is the verdict rendered your verdict?
Yes.
Juror number 7, is the verdict rendered your verdict?
Yes.
Juror number 8, is the verdict rendered your verdict?
Yes.
Juror number 9, is the verdict rendered your verdict?
Yes.
Juror number 10, is the verdict rendered your verdict?
Yes.
Juror number 11, is the verdict rendered your verdict?
Yes.
Juror number 12, is the verdict rendered your verdict?
Yes.
All right. Thank you, ladies and gentlemen. At this time, as we discussed when you were originally impaneled, the verdicts in this case were in the first degree, which entails that you as a panel will have to make a decision on the sentence involved in this matter. We are going to begin that on Monday. You'll be released today. You'll have Friday, Saturday, and Sunday off. I'm going to have you come back on Monday at 9:30, and we'll begin the second phase, the sentencing phase in this matter. Again, you will continue not to read, talk, tweet, blog, or anything about the case. You are still the jury deciding the second phase of this matter. So although you have made a decision on the guilt of the defendant, the sentence could be affected by you reading something or hearing something or talking to somebody about this. So at this time, I'm going to go ahead, your notes, your jury instructions, we're going to keep. They'll be back. You'll need those for the second phase, so we'll have them right back here. You want to put them in the envelope, and they'll be right back on your chair when you get back here on Monday at 9:30. As I told you, I believe that we are a day ahead of when we originally had said that we would go through. Depending on how the testimony goes on Monday, my thought is that on Tuesday I will do the exact same thing I did today, which is I will bring you back on Tuesday, I will instruct you on Tuesday, and you will begin to deliberate. So I'll give you more information on Monday before you leave, because I'll know after it goes on Monday how the timing is. But right now, my guess is that you'll be deliberating for that matter on Tuesday. And so at this time you are released. Keep your jury badge. I'll keep everything else, and we'll see you in the jury pool room at 9:30 on Monday morning. All right? Again, keep that number with you if there's any issues. Okay? So at this time, I'll thank you, and I'll release you for the day.
Jury is out of the presence of the court, Your Honor.
Thank you. He can be seated. We have a few more things to talk about. All right. What I'd like is for the individuals who are going to be handling the second phase to be here at 8:30 tomorrow morning. We'll discuss the jury instructions so we can go over them and make sure that we have any disagreement at least discussed and reviewed before we begin on Monday. There's a part where I have to read them an instruction about what they're going to do, and I want to make sure that we have all that agreed to. Defense, how many witnesses do you believe that you'll be calling? I'm not holding you to it. I mean, just a rough ballpark figure.
We have listed 12, I believe. I don't think any of them will be that long.
Okay.
We do have a Skype session scheduled Monday, 3 to 5.
Okay.
And I'm assuming the openings aren't that long.
Okay.
I believe we can probably get through most of them, if not all of them.
The challenging task of delivering a just sentence fell upon the judge. They had to ensure that the victim's family received closure while also ensuring the suspect received a fair sentence for his horrible crime.
I don't believe there's anybody else, Judge.
All right. Vince, do you want to rise with your client from the podium? Is there anything that defense wants to present or any statements the defendant wants to make before I present, before I enter the sentence?
I would just like to say I'm sorry to the victims of the family. I know that's not enough, but I just would like to make peace and hope that they don't hold on to that hate in their heart, because a heart filled with hate is not free. I'm truly sorry.
that it? Ladies and gentlemen, if you can't control your emotions, everyone's had an opportunity to speak. You can step out, okay? You just need to finish up this for today. Mr. Matos, before we proceed with the sentence, I have a few things to say. We all know what your sentence is going to be. It was decided by the jury. It was decided by one vote, and Mr. Pure made sure of that. He asked the jury if any one of them would spare your life, that they do so, and they did. The last person who they chose, Margaret Brown's case, the vote in your case was 11-1. That means one person on that jury felt enough sympathy, mercy for you that they decided that you did not deserve the death penalty. So for that, I don't have to make that decision. It's not something that I ever wanted to do or wished to do. But if there was ever a case that I've ever heard that 12 people would have decided that death was appropriate, this is probably it. But that's their decision. I believe wholeheartedly in the judicial system, and I believe that those 12 people made up their mind, and that sentence will be imposed on you. But I also agree with the victims in this case. This was the most selfish, self-centered, evil thing that I've ever heard. That you took the stand and you said that you did all of this for your son is ridiculous. Your son was in the house when this occurred. He was either in the room or within 65, 70 feet of when you shot his mother, shot his grandfather, and then waited 5 hours, by your own admission, to walk downstairs and beat his grandmother to death. In those 5 hours, you must have sat in that house with your son. He was there. It's 6 o'clock in the evening. He's not asleep. He's not locked in his room. You're sitting there with your son, with his mother, his grandfather, and a man who gave his life for those people. You sat there with him and went downstairs off his grandmother. And you did that for your own selfish reasons. Maybe it was your age. Maybe it was that you felt that they had done something to you that you needed to get revenge for. But there was no remorse. Just saying you're sorry doesn't make it so. You're not sorry for what you did yet. Maybe someday you will be. You weren't sorry that day. You weren't sorry when you took the stand, and you're not sorry now. Your son will grow up without a mother, and without grandparents, and without a father, just as you did. But worse than you, he will grow up without a father because he will know that his father, his mother, and his grandparents. There's no worse life than that. Hopefully, with the love that he has from the Piles and the Browns and all the other family relatives that he has, he will learn to understand and be happy and learn the things about his mother that he did not know because you took her at such a young age of his. There's nothing worse than losing a parent at a young age, but to have them taken from you by your father, I can't imagine. So hopefully, some way, somehow, through the love of the family that he has here, he will grow up to be a healthy, happy, productive, hardworking, loving person. But that's not because of you. So to say that Tristan is your whole world, I don't believe that. I don't believe Tristan was your whole world. I believe that you did this because you were selfish. And based on the decision of the jury, I sentenced you in count 1 and count 4 to life in prison without the possibility of parole. In counts 2 and 3, I sentenced you to life without the possibility of parole. However, that's with a discharge, include charge. which means hopefully that no matter what happens with the legislature, no matter what we decide on life or in your case, you will never, ever be released from prison. Can you afford to hire an attorney for your appeal?
No, Your Honor.
All right, so at this point, I will appoint the public defender to represent you for appeal. State, is there any costs associated that you're asking me to impose?
Yes, Judge. $5,001 to victims' crime compensation.
All right, $5,001 to crimes compensation. There's usually $5 in court costs and fines. Does the lawyers want me to go through where all that money goes, or you just waive the breakdown of that?
We'll waive the breakdown.
All right, there's also $250 to the public defender's office, and you have 30 days to appeal. State, is there anything else I need to announce?
I did. We are asking that all sentences run consecutive.
All the sentences will run, life will be consecutive to each other. So counts 1 is consecutive to counts 2, consecutive count 3, consecutive count 4. And you have 30 days to appeal. Good luck. I'm sorry? No. You're supposed to. I'll give you a number in case you need to put it in there.
You doesn't get it if you don't order it. So.
I don't want to create a case of a deal.
Sounds
So
good.
put it in there.
Absolutely.
Once your words or gunshots are released, they're irretrievable. The impact, deeply felt in this case, reveals the true extent of their cutting power through life.
Charge ID 202-7584, a finding of guilty is entered. The defendant is sentenced to New Hampshire State Prison for not more than life, nor less than 50 years. There is added the minimum sentence of disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year.
In April 2022 in Vermont, Stephen and Wendy Reed were strolling home when their peaceful evening was shattered by the monstrous act of Logan Clegg, who ruthlessly gunned them down. The criminals' downfall began upon arrest. Faced with their own demise, criminals often display unexpected behavior.
Jail's second-degree felony for possession of stolen. Misdemeanor A, carrying a concealed without a permit. Stolen. And retail theft because you stole from Walmart.
Is that even worth $25?
I don't have any idea. They haven't added it up yet, but
how can they charge me if it's not even worth that much? Well, the state
I don't know what state doesn't charge people for thefts under $25, but in Utah, if you take something without paying for it, it's called theft, and you can be charged for it. Or 99 cents. You're not getting thrown in jail for the retail theft. You're thrown in jail for the second-degree felony. I tried to explain that to you as we walked out here, but instead you wanted to start calling me names and telling me off. If you'd like, I'm happy to explain it to you. Would you like me to explain it to you? I'm sorry?
I think it's enough.
Okay. So, I've got my questions that I have to ask. Do you now understand why you're going to jail? Okay. From your encounter with me and the other officer, are you sick or injured in any way? No. Okay, do you have any questions for me? No. Excellent. All right, man, a couple of things. Anything on you that I didn't find that the jail's going to find? Okay. I'm going to assume, since you already talked about a lawyer, that you don't want to talk to me without a lawyer present. That'd be a safe assumption.
I'm asking purely for
Okay. Well, do you want to talk to me about the stolen? Because if so, I've got to read your rights. Since you already asked for a lawyer, I'm assuming that you prefer to have the right to a lawyer. But if you'd like to talk to me about the stolen, we can have that conversation.
I bought it. I really don't know where it was stolen or who stole it. That's all I got to say about it.
Okay. So, no point in me reading your rights because that's all you're going to say about it. Accurate?
Yeah.
Okay. Last thing, dude, you can hate me all you want, but I'm still shaking from the fact of you not cooperating initially and having, like, that's so dangerous, bro. I don't know, bro. Like, how am I supposed to know? Right? You've got on you and you're not pulling your...
They ambushed me at the door like a bunch of cowards.
Would you rather us have chased you down? We did
Not
safely
ambush me the
as
second
possible.
walking out the door.
Well, that's right. State code talks about that if you pass all points of sale after you've concealed items, that's when we're allowed to stop you. So again, if you want to have legal discussions, then freshen up on your legal, and we can do that. But I'm trying to explain to you, and I'm trying to warn you because you're not going to stay in jail forever. And if you have a on you, chances are you're going to go get another after this. My point is that it's super dangerous to not cooperate 100% when you have it's even more important.
I was being arrested. It was just a sweatshirt and some little bag. Why would I start immediately? Hands up. Why would I do that?
I didn't say hands up. I said, pull your hands out of your pockets for me, please. That's exactly what I said, and it's all on camera. And you kept your hands in your pockets, right? All I'm trying to do, dude, you can argue with me all you want. I'm just trying to warn you for the future, okay?
I just go to jail right now.
Go ahead and step out. Just face the car right here for me, and I'll grab your hat for you.
Can I button up my shirt?
Yes.
This stupid bandana off. Like cop stuff.
That's humiliating you.
Don't even
That's why I'm doing what you said. All right. We'll keep it unbuttoned.
Such a sick.
Alright, sweet. They asked me to do you a favor and then start calling me names. That's super how you get favors done.
Shut up.
Now I'm a coward. Okay.
Yeah, 3-on-1,
Okay.
ambushing me at the door, putting me in handcuffs.
It's called safety, and I'm glad that was the case because you had a shit this way. How would you propose we do that differently?
But you give me a chance to
you were
pull
in
it out so we can fight.
If you were in my shoes, that's what you want?
Yeah,
Okay.
man to man.
Yes, it does. First off, you wouldn't stand any chance whatsoever.
Good, I'd rather die in prison. You second.
Okay. Well, then I guess I'm glad that you didn't force me. Go ahead and walk. I'm glad you didn't force me to have to.
Even if unaware of the crime at the time, the criminal may grasp its severity when it is recounted to them later.
This alleges that Logan Clegg, on or about April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of second degree, in that Logan Clegg knowingly caused of Jeswendy Reed by her with a in docket number 217-2022 CR 1226, charge ID number 2027585C. This alleges that Logan Clegg, on or about April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of second degree, in that Logan Clegg knowingly caused the death of Stephen Reed by shooting him with a in docket number 217-2022 CR 1226, charge ID number 2053091C. This alleges that Logan Clegg, on or about April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of second degree, in that Logan Clegg recklessly caused the death of Jeswendy Reed under circumstances manifesting an extreme indifference to the value of human life by shooting her with a In docket number 217-2022 CR 1226-205-8092C, this alleges that Logan Clegg, on or about April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of second-degree murder in that Logan Clegg recklessly caused the death of Stephen Reed under circumstances manifesting an extreme indifference to the value of human life by shooting him with a gun. In docket number 217-2022 CR 1226, charge ID number 205-3093C, this alleges that Logan Clegg, on or about the April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of falsifying physical evidence, in that Logan Clegg, believing that an official proceeding or investigation was about to be instituted, altered, destroyed, concealed, or removed anything with a purpose to impair its verity or availability in such proceeding or investigation, to wit, by moving and concealing the body of Stephen Reed. In docket number 217-2022 CR 1226, charge ID number 2053094C, this alleges that Logan Clegg, on or about April 18th, 2022, at Concord in the county of Merrimack, did commit the crime of falsifying physical evidence, in that Logan Clegg, believing that an official proceeding or investigation was about to be instituted, altered, destroyed, concealed, or removed anything with a purpose to impair its verity or availability in such proceeding or investigation, to wit, by moving and concealing the body of Jeswendy Reed. In docket number 217-2022 CR 1226, charge ID number 2053095C, this alleges that Logan Clegg, on or about April 18th, at Concord in the county of Merrimack, did commit the crime of falsifying physical evidence, in that Logan Clegg, believing that an official proceeding or investigation was about to be instituted.
The question of sentencing in any case is hard. Most people who are sentenced will re-enter society at some point. The hope is that they will emerge from their punishment and their time in custody rehabilitated and less likely to offend. For some people, however, who commit acts so senseless, so violent, and so terrible, the sentence needs to be crafted in a manner to make sure that they can never be in a position to hurt another innocent person. From my perspective, this is such a case. Any rehabilitation of the defendant should occur when he is safely in the four walls of the prison. Stephen and Wendy Reed were good people. They should have been able to enjoy their retirement together, their children, their family, and their friends. Go on many hikes together. They should have been able to do that. Logan Clegg is a stone cold, violent, nothing more. He Stephen Wendy Reed for no reason. His statements today ring hollow. He deserves nothing less than a sentence that fully reflects the magnitude of his crimes. And for that reason, I'm going to fully impose the sentences as recommended by the state. On charge ID 2027584, a finding of guilty is entered. The defendant is sentenced to New Hampshire State Prison for not more than life, nor less than 50 years. There is added the minimum sentence of disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year. He has pretrial confinement credit of 422 days. Their sentences stand committed commencing. He shall pay restitution of $17,564.39, $3,878.08 to Lindsay Reed, $13,686.31 to the victim's compensation fund. I know, given the sentences that I've imposed in his circumstances, that he has no ability to pay counsel fees and expenses. that order throughout for the rest of his oath. He's to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation parole officer. The Department of Corrections shall have the authority to award him earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence and return it to its rightful owner. The defendant is ordered to be good behavior and comply with all terms of the sentence. On charge ID 2027585, finding he's guilty is entered on that charge of second. The defendant is sentenced to New Hampshire State Prison for not more than life nor less than 50 years. There is added to the minimum sentence of disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for any part of the year. The sentence is to be served as follows. Stand committed. The sentence is consecutive to the sentence that I just read. Again, no responsibility for counsel fees. And counsel fees programs as directed by the correctional authority or probation parole officer. Subject to the provisions of RSA 661A, Department of Corrections shall have the authority to award him earned time reductions against minimum maximum sentences for successful completion of programs while incarcerated. I truly hope he engages in rehabilitation, but there's no chance, if this sentence holds, that he will spend a day outside of the prison. Law enforcement agencies may destroy the evidence, or return it to its rightful owner. He's ordered to be of good behavior and comply with all terms of the sentence. The remaining charges in charge of D 2091545 for falsifying physical evidence, 2053093 for falsifying physical evidence, 2053094 for falsifying physical evidence, 2053095C for falsifying physical evidence, and 2053096 for being a convicted felon in possession of a dangerous. These sentences are identical and concurrent to the second consecutive life sentence, 50-year to life sentence that I've just imposed. Each of these sentences is as follows. The defendant is sentenced to New Hampshire State Prison for not more than 7 years, no less than 3.5 years. There is added to the minimum sentence disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence to be prorated for a part of the year. The sentence to be served as follows. Stand committed, consecutive. Again, these are all concurrent with each other and consecutive to the first sentence and concurrent with the second 50 to life sentence.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.